All right. So welcome. Today, some of the special education attorneys from McAndrews, Mehalick, Connolly, Hulse and Ryan are going to reveal how they would grade these common parent responses. So if you've ever wondered whether you should be asking to record your IEP meetings, excusing IEP team members, or sending an agenda to your IEP team in advance of meetings, this is for you. And some of these are going to surprise you with how we've graded them, I bet. So I'll be facilitating the discussion. I'm Jacki Lembeck. I'm a partner at McAndrews, Mehalick, Connolly, Hulse and Ryan. And I'm here with Michael Connolly, our supervising partner and COO at the firm, and attorney Rachel Rosenberg, who will also be presenting on back to school issues for 2025. So check that out on our YouTube page as well. All right, so to get us started, what's the first one here that we are going to check out? All right, recording IEP meetings. I can't tell you how many clients come and they either ask us whether they should be or they tell us that they did record the IEP team meeting. But let's hear more about it. So from Michael Connolly, what would you give this, A to F?
So it really depends on the reason why and how they went about doing any kind of recording. So if the parent has a disability of their own or has difficulty understanding and is doing the recording in order to be able to go back later on and listen and make sure that they understood what was discussed and really use it as a tool to participate in the meeting, and they gave the district a heads up notice beforehand and got everybody's consent, I think it's absolutely fine, and I would give it an A for that. If, however, a parent is doing it for the purposes of recording because there's distrust and we don't think the district is telling the truth, or people say things and then they say something else later on, I would give that a D to a D minus, because I've never found it to be helpful. I've never found hearing officers willing to go and listen to 2 hours worth of IEP meetings to find something that might be off from what the district is saying. Now, I've just never found it useful in a hearing. I've never found it useful in resolving things, and I've never found it useful in getting to a place in an IEP meeting where you're going to come to an agreement. And more often than not, I would say it causes people to speak less freely and be conscious of what's going on, and you don't have as much of a give and take in the IEP meeting. And if a parent decides, particularly in the state of Pennsylvania, as opposed to maybe some other states, that they are going to not tell the district and not get consent and record the IEP meeting without knowledge, I would then give it an F or an F minus, if you can give it F minus, because in the state of Pennsylvania it is a two-party state, which means both the recorder and the one who is being recorded must give consent to being recorded, or it is illegal. It's a crime to record somebody in Pennsylvania without their consent. Other states, it's a one-party state. Delaware, for example, is a one-party state, which means only the person doing the recording needs to record or have consent to the recording. So, but in Pennsylvania, it's gotta be both.
All right, so they're not really going to get that gotcha moment that some people think they may be getting from that recording.
Very, very. I don't know. I can't think of a time that I got a gotcha moment on a tape from a client.
All right, our next one here, signing a notice of recommended educational placement, or a NOREP, or what might be called a prior written notice form, basically the form that's going to have a parent consent to revisions to a child's program placement in an IEP. Signing that form at the IEP meeting. Rachel, what are your thoughts?
Or I would give signing the NOREP at the meeting an F, or the F minus that Mike just discussed. It's really important after a meeting to take the NORAP back home with you so you can take your time to really consider what was discussed at the meeting. Sitting at an IEP meeting, there can be a lot of new information being thrown at you, a lot of different opinions. Maybe you disagree with some of what's being discussed. Maybe you don't disagree with some of what's being discussed. But either way, it is really beneficial to bring that home and to think about it and to make sure that you're signing in the way that aligns with your thinking. The only thing I would say is that you do need to return that NORP within 10 calendar days of the IEP for your signature to be taken into account.
Yeah, I think that's so important. And also what I see kind of going alongside this is that sometimes families are asked to sign the NORAP before the actual document of the IEP has been finalized. Maybe they at the meeting, they agreed to make some revisions and they're kind of given a NORAP, but their IEP still has a draft mark on it. They haven't gotten the finalized one. And so I would, for all the reasons that you said, plus this, I would say, use your time, make sure you know exactly what should be in that document. Sometimes mistakes are made, and that you use that opportunity to correct anything before you go ahead and approve or disapprove. All right, back to Mike, asking to observe the student's program and placement.
All right, and we're here, I think we're talking about the student's current program and placement, and I would give that a B grade. Understand though that there are going to be some reasonable restrictions that a school district can place on that. You're should be making arrangements ahead of time with the district to do the observation. There will likely be, they might put limits on how long of an observation, how many observations in a school year can occur. And these are all considered to be reasonable restrictions that a district can place on that. It might be that somebody in the district will accompany you on any sort of observation, and somebody else will be in the room with you observing, so that the district is observing what you're observing at the same time. Again, all reasonable, and as long as you work within those reasonable restrictions and you give the district notice that and make arrangements to do the observation, I definitely give it a B. It can give you some information that you may not have otherwise had, with the understanding that, usually when people are being observed, they're kind of on their best behavior, if you will. So, if there are issues or problems going on in the classroom, the observation may not really get you what you want, but you never know. The kind of observation by surprise, or not telling the district that you're going to come in to observe and just showing up and demanding to be able to go in and observe in the classroom, that would go from an A to an F pretty quickly. You got to make sure that a B to an F pretty quickly. You got to make sure that you're reasonable in the way you go about making the request and making the arrangements for the observation.
Yeah, and I would add that while your presence observing may kind of change the way staff interact, it also may change the way your child interacts that day. So, the follow-up question I think you always want to ask at the end of an observation is, was this a typical day? And I've heard that from a lot of evaluators who always ask that as part of their practice. So you can figure out, was the child maybe a little extra excitable because, they understand that a parent, a guardian is in the building nearby, and that can certainly have an impact? Or was this, actually the behavior or the level of interaction that the team is seeing all the time? Okay, Rachel, what are your thoughts on touring a program that's recommended to a family by a school district or a charter school?
I would give this an A. There is no downside to going to tour any program that the school district recommends, but there is a downside to not doing so. So if a school district is recommending a different placement from the one that your student is already at, it is only to your benefit to go and give that placement a tour. Even if you think you have no interest at all in sending your student to this school, it is so important that you go tour it. Because you might change your mind. If you go to the placement, it's good to keep an open mind and see, there might be a very good reason why the school district is recommending this placement for your child. And it's important to go and give every potential placement a consideration. Even if you really have no intention in sending your student there, it's important that you remain cooperative with the school district by taking a look at what they're recommending and seeing what you think.
I totally agree. I also think it's an opportunity to ask those questions that you have. If there's something that says to you, like, oh, I read something about this school that I really didn't think was appropriate for my child, they don't use this type of program for my child, you can ask those questions, and it always will be more persuasive in a hearing or in a follow-up IEP meeting to be able to explain with facts what you saw and observed. So, better to say, I observed that this classroom was this size, and, I don't think that meets the needs of my child, versus I heard or I think that the school might be too big for my child.
Okay.
All right, to Mike, how about following up phone calls with your child's school or charter school with an email?
I would generally give this an A. I think it's very good to memorialize what discussions occurred for multiple purposes. One, so that it's an established record as to what was discussed, particularly if there were any promises made that something was going to be done or not done. And it also gives an opportunity for a parent to make sure that what they understood on the phone was accurate. They accurately understood what the district was saying, and by putting it back in your own words, your understanding of what was discussed, it gives the opportunity, if there is something that's not accurate about it, the district the opportunity to write back and say, no, what we meant was whatever it is, and you've got that documentation. And if they don't, then I think it's fair to assume and act as though your understanding of that conversation was in fact accurate. I would, if you do it in what I would call an Oreo cookie email, I would go from an A to an A plus. And an Oreo cookie email is essentially, you've got your two cookies and the cream filling. The cookie part, the first cookie part, is something nice, something good. Thank you for taking the time to speak with me, whatever it is. And then in the middle is all the substance, some of which may be critical of things or concerns about what's going on with the district or things of that nature. And then at the end, again, it's some sort of nicety or compliment to the district, so that the tough stuff is kind of sandwiched in between two compliments or two nice things about what's going on, or the district, or taking the time to speak with you, or whatever the case may be. On the other hand, if its emails are in certain cases daily and they're page long emails, while there may or may not be justification for it, it's very easy to take emails like that and turn them around and make a family look to be unreasonable or over demanding. Because remember, if you ever end up in a due process hearing, hearing officer doesn't know you necessarily, or the specific individuals of the district, might have never met those individuals before, has no personal relationship with anybody, so he doesn't know you. So he or she is judging based on what's in the records that are presented to them. So it's easy for the district to do that. So in that kind of situation, that A or A plus, quickly works its way down, to a D or an F, depending on what's, how frequently and how long and how much information is in is in these the email. So you want to be to the point, succinct, address what you need to address without a lot of extra in the emails that you send, and always write them thinking that somebody else down the line may end up reading that email to make a determination or a judgment, not only about what your child may or may not need, but your credibility and who you are. So always keep that in mind when you're writing an email.
Yeah, I totally agree. And while still agree, I'm going to play the other side of it a little bit. And to anyone from, school districts who may be listening here, my personal grade for giving like word count limits or number of email limits or something like that to a family is also a D-. I think that's really a problematic thing. Families have a right to meaningful parental participation. Some students are really complex. Absolutely agree that, families should be reasonable. They need to be respectful of, the teacher's time and the team's time. And, you don't want to appear unreasonable, but on the other side, saying, I won't read any more past this, I also think doesn't make the cut.
Absolutely. As sometimes, and honestly, it could go either side. There's certainly times where I've wanted to respond to emails and do the all caps shouty thing back to whoever I'm dealing with on the other side. But you've got to, and you may be completely justified in wanting to do that, but you got to kind of tamper that back and try and keep that into check, and make sure that you are really being as professional as you can in the email, because again, you want to write it as though somebody else down the line that's not involved in this, who's going to make some judgment calls, is going to read that.
All right, Rachel, what are your thoughts on sending a proposed agenda to the school team before a meeting?
So there are some varieties that go along with this as well, but in general, sending a proposed agenda to the school team before a meeting, I would give that a D-. It can come across, even if, there are lots of things that you want to discuss in a meeting. An IEP meeting is a team meeting with lots of different people. And the idea is that all of these different people who have a role in your child's education are going to come together to have a meaningful conversation to talk about the best way for your child to make progress. So if you send a lengthy agenda to the team beforehand, it could come off a little pushy, as if you're trying to dictate the meeting rather than trying to have a team meeting where you're all collaborating together. So the way to turn that D- into an A, if you have a couple of things that you just really want to make sure are discussed at the meeting because they're main priorities to you and you think they're really important to be discussed, is to send an email before the meeting with maybe 3 different items that you just want to make sure are discussed at the meeting, saying that these are some concerns and you want to make sure we talk about them at the IEP meeting. I wouldn't send an email with 20 issues because that, has the same problem as sending a formalized agenda. But if you send an email beforehand with just a couple, 3 things that you want to make sure discussed, that could be a really helpful way to guide a team meeting. Another thing that I think would be an A would be to make an agenda for yourself, just some personal notes that you have that you don't share with the team, that if you have several things that you want to make sure you bring to the team and or discuss at the meeting, it could be a great way to make sure you don't miss anything if you have them all on your own list, so that at the end of the meeting, if you see the meeting is starting to end, you want to look down at your notes and make sure you covered everything, so that if you didn't, you can bring something up. That's always a helpful way to stay organized, and make sure that all of your concerns are covered.
I like that. I like just a difference in approach, bringing it from the D to an A, because what you're doing in the meantime is avoiding the power struggle, but still hopefully getting to what you want, a productive meeting where you got to talk about the things that were most important to you. Okay, to Mike, signing releases for the school team to communicate with providers. What grade would you give that?
Yep. So generally speaking, I would give that an A, generally, particularly if there's kind of overlap in what the private providers they're looking for information from and what the school district is doing. So yeah, an example would be child gets speech and language services in school, and a child is also getting private speech and language, or a child gets behavioral support in school and they have behavioral support at home. It's oftentimes important for those individuals to be able to communicate, to make sure they're not using strategies that are at odds with each other. One strategy in the home, one strategy in school district, and they kind of compete with each other, and they make it a little bit more, confusing for the student, more difficult for the student to be successful, because they're expecting some sort of different support or different response, particularly in the area of behavior. That can be true. And then there could also be situations where, if you're relying on recommendations you're hearing from your doctor or getting from your doctor, and you're providing them in written form, and the district wants to be able to speak with the provider who's making the recommendations. Again, you want to provide that consent and let them have that communication, because otherwise, if you end up in a dispute about it, it looks as though things are trying to be hidden. Whether that's the case or not, it can have that appearance to a hearing officer. If you're in a hearing and you're not giving consent to the district, but you want the district, or to speak to somebody, but you want the district to follow the written recommendations of that individual as it relates to school programming. If there are things that are completely not relevant that the district wants access to, there could certainly be some situations where I would say there's no need to give the consent, but I would say in the majority of them, you do. I would also caution against conditioning that consent, or saying that you'll only give consent if you can sit in on the phone call. It creates an argument that I don't know if the doctor or the provider or whoever is being completely honest with me, because they may not want to say something that the family may disagree with if they're on the phone. And I do understand the perspective of, hey, I want to make sure that with what I'm hearing from the doctor, what the district's hearing from the doctor, are the same thing. I just think it's better to follow up with the doctor after the call and talk about what was discussed or said, or even if the district says, well, this is what we got from that call, have the follow-up call with the doctor or provider. I think that's better than insisting. I think it's fine to ask if the district doesn't mind, but conditioning the consent on that, I think, can prove problematic.
Yep, really helpful, and definitely something that comes up, all the time.
It does.
Particularly, we're seeing a lot in, with students who may have some mental health needs, and that can be something that's kind of difficult for a family to think through why this consent is even being requested of them. But generally speaking, it sounds like erring on the side of collaboration, unless there's some, really particular concerns, is probably the way to go.
Right.
All right. Records review only reevaluations. Rachel, what are your thoughts?
I'm not a fan of record review only reevaluations generally. I would give that a D-. Students change a lot over a short amount of time, let alone a short amount of time in the 3 years in which Pennsylvania requires school districts to do evaluations. Evaluations are being done every 3 years, and a lot can change in a 3-year period. So in general, it's really important that a school district does a comprehensive evaluation of a student every 3 years, so that we can be best in tune with what their needs are. Especially when big decisions are being made, transition plans, graduation, it's important to have the most up-to-date information so that good decisions can be made to account for the students' needs. The only scenario, I would say a D- rather than an F, because The only scenario I would consider agreeing to a records review only reevaluation would be if the student was just comprehensively evaluated. So for instance, a student just received an independent evaluation or an IEE, and the school district wants to update their reevaluation to include that testing. That might be a scenario where a records review only evaluation would be okay. But in general, there are very few instances where something like that would be appropriate. Even if there's a student with, let's say a student, for instance, doesn't have any learning disabilities, maybe just has some minor attention issues, is doing really well, getting good grades, not having any behavioral issues. So they want to do a records only review. Even in that instance, there are likely some checklists that would be helpful to get an up-to-date evaluation of that student. So there are really only very rare circumstances, like for instance, if an independent educational evaluation was just done, that we would think that a record review only reevaluation would be a good idea.
Yeah, I totally agree with you. And I think that for families who are being asked to give permission to a record review only, that's kind of your opportunity then to open a discussion to say, I really feel that there should be testing. And then, hopefully that's something that may be able to get worked out right then in the beginning, rather than give permission to the record review only. The school district or charter school finishes it within their 60 calendar days. And then you get a report back and you go, that wasn't enough. Like, I still have a lot of questions.
Yeah. And then
so it could be an opportunity.
Yeah. Yeah.
All right. So Michael, making a copy of daily behavior sheets that may come home with a child for the parent to see.
I would give that an A plus. I think any sort, whether it's behavior sheets, a communication log, any sort of written back and forth that goes back and forth between the home and the school, that it's an excellent idea for the family to make copies of that when it comes home, of that day's behavior sheet or log, communication, or whatever it is, so that you have a copy of it if you need it. And if it's electronic and things are going back and forth via email, to make sure that you don't delete the emails and you save the emails in the event that you need to go back to those. I think it's there's absolutely no downside to it. It's definitely a good thing to do, and an A plus move.
Yeah, I would add, I would not bank on the school maintaining that, and that you can just request it under FERPA, the Family and Education Rights and Privacy Act. That does allow parents to get a copy of their child's education records, but a school district is generally only going to give you what they consider maintained. And those daily behavior sheets are the type of thing that when we request records routinely, we may not get, or may not get at the first try at least. So just because you believe that the school's keeping their own copy, that's great, but I really like the A to A plus to have your own. All right, Rachel, what about when families are asked to excuse IEP team members?
So this depends. It depends on who the team is asking to excuse. If the person is non-essential to the conversation or your main concerns going into the IEP meeting, I would give excusing those people a B. It's still best practice to have the entire team there. That would be the A, but it might not be the end of the world to excuse somebody who's not very essential to the conversation, to the goals that need to be discussed, to the progress that you're talking about, to the behaviors, whatever the main concerns you might have are going into the IEP meeting. If that team member is not essential to that conversation, it could be a B to excuse them. That said, if the person's input is critical to the conversation, then it would be a D to excuse that person. Let's say that your student has a learning disability related to math. You wouldn't necessarily want to excuse the math teacher because you would want to hear their input into how the student is doing. And the most important part of an IEP meeting is to have those conversations about how students doing what they need. So you want to make sure that the players that have the key information are at the meeting.
I agree. I would even go a step further sometimes to think about whether someone should really be there for the full meeting. So there is, and I totally understand it, a temptation to like have one person report out, and as soon as they're done with their reporting, let's say the speech language pathologist, oh, reported out on the speech goals, can the speech pathologist be excused? But if a student really has a language-based disability that is potentially impacting them through the day, that person's expertise is going to be relevant when we're talking about the general education teacher's input, when we're talking about, how to address any listening comprehension needs that might be happening in the school. So, I think to Rachel's point, definitely just kind of figuring out like what are the biggest concerns that we're discussing and what is that person's input potentially. And if it seems critical to have that person, then, let's work with the team to find a way to make that happen. Okay, and our last one for today for Michael, waiving the 10 days to review an evaluation report or a reevaluation report before the IEP team meeting. So parents are sometimes asked if the evaluation just came out, whether they'll waive their 10-day review period so that an IEP team meeting can be scheduled sooner. What are your thoughts? Is that a good practice?
So again, this is one of those situations where I think it depends on the circumstance. And again, this is where a district has to, within 30 days of issuing an evaluation report or a reevaluation report, convene an IEP meeting. But the first 10 of those days, they can't hold it during that period of time because the family has the right to have those 10 days to review. So if it's a situation where you feel you've got enough time, they want to schedule it in within those first 10 days, but you feel you had enough time to review the IEP, to be prepared to really meaningfully participate in that IEP meeting, then I think it's fine. I would, I'd give it a B to waive the timelines in that situation. If it's a more complicated situation, it's a longer evaluation. I mean, sometimes a real comprehensive evaluation might be 50, 67. I've seen them 70 pages long, with tons of testing results, with a lot of background and history, teacher input, multiple observations in different settings within the school. That's a lot of information to digest so that you can effectively participate in the IEP, even know what questions that you might have to ask in an IEP meeting as a result of the evaluation. Then I would say it is not a good idea to waive that 10-day time frame, and I would give it a D at that point to waive it. You really should take the 10 days. If not getting the district to push it closer to the end of the 30-day so that you have enough time to really review that evaluation report, understand it, potentially have a conversation with the school psychologist that drafted the report ahead of the meeting, so you can ask some of the questions that you might need answers to in order to think about and decide what you think is appropriate way to address certain things in the IEP so that you can advocate on behalf of your child, ask serious, thoughtful questions about what the district might be proposing. So it's definitely one of those situations where it depends on the nature of the needs of your specific child and the nature of that evaluation.
Yeah, I agree. And I guess I would just add that if, as a parent, if you feel like I've read it, I really understand what it says here, I just have my, particular questions about it, then going to a meeting and saying, we don't need to read this off the page to me at the IEP meeting is something that I think generally is a good practice too, maybe a B+ there. Because if you feel like you've got it, have that dialogue, of course, with the team members, but you might not need someone to read you the results that you just read, taking up meeting time, because then sometimes you never get to discussing the program, which was the point of the IEP meeting. If you're trying to do both of those, review and IEP meeting in the same shot. All right, so there you have it. The grades are in. These are our thoughts on some practices. I bet some of them did surprise you. I know over time in working in this area, you kind of learn that sometimes what sounds like a great idea on paper just doesn't pan out the way that was anticipated. So we hope that you benefit from our years of experience and some tips that we've been able to give you here. And do check us out and feel free to contact us if you have any questions.
Thank you.
Thank you.